to this discussion of affirmative remedies in housing litigation. And before we begin and before I introduce the panelists, I'd like to take a few minutes to sketch the background of the issues we're going to be dealing with tonight. Since the passage of the 13th and 14th Amendments to the Constitution in the aftermath of the Civil War, racial discrimination in a broad range of social, economic, and political transactions has been prohibited as a violation of civil rights. More recent legislation, beginning with the 1964 Civil Rights Act and culminating with the recent 1988 amendments to the Fair Housing Act, has extended some protection against discrimination to ethnic minorities, women, the elderly, and the disabled. Nevertheless, most controversy over civil rights, which come before the courts, continue to be based on race. Until about 35 years ago, a determination by the courts that a practice was racially discriminatory was customarily accompanied by an order to terminate that practice. Thus, in 1917, when the Supreme Court in Buchanan versus Worley struck down the widespread practice of racial zoning, it ordered the practice halted. But it required no action to alter the established patterns of racial segregation which had previously been enforced by law. Similarly, in 1948, when the court found in Shelley versus Kramer that enforcement by the state of racially restricted covenants in property transactions was an impermissible use of the police power, it ordered a halt to the enforcement of such covenants. But as in Buchanan, the court did not require that any steps be taken to undo the established patterns of residential segregation which years of prior enforcement had helped to establish and maintain. However, since the landmark decision in the 1954 case of Brown versus Board of Education, the courts have increasingly responded to findings of discriminatory practices with orders that specific steps be taken to undo the effects of those practices. Such remedies have been mainly applied in cases involving a range of discrete issues: voting, education, employment, and housing. And while the discussion today is concerned with the broad issue of affirmative remedies in instances of government rather than private discrimination, we will focus in that context on remedies for housing discrimination. We focus on housing discrimination not only because of the national interest aroused by the Yonkers case, but also because housing has unique characteristics which distinguish it as a special case among civil rights issues. First, housing is a pervasive element in the web of racial discrimination. Housing is an important influence on access to employment and schools, as well as on electoral patterns and their outcomes. Second, the quantity, quality, cost, and location of housing are directly and significantly influenced by a broad range of government activities and policies. These include not only land use planning, but the regulation of land use and buildings, site selection and tenant assignment policies and practices for public and subsidized housing, displacement and relocation resulting from public redevelopment and the construction of highways and other public facilities, federal tax policies, mortgage insurance, rent subsidy programs, and investments in transportation. The decision in Yonkers reflects the increasing recognition by the courts of the diverse and interrelated government actions which profoundly affect housing. These housing-related policies and practices of government have frequently reinforced patterns of segregation, provided fewer benefits to blacks and other minorities than to whites, and have disproportionately disrupted and restricted black and other minority communities. Finally, housing, unlike other subjects of civil rights controversy, has a fixed-in-place bricks and mortar permanence that defies convenient rearrangement. For example, remedies that require the adoption and implementation of a hiring or admissions plan, or the rearrangement of voting district boundaries can be rather quickly and relatively inexpensively implemented. But a remedy which requires the production of new low-income housing in areas previously closed to minorities must overcome physical, temporal, and financial obstacles reinforced by the adamant opposition of elected officials who transform into public policy the attitudes, customs, and practices of their majority white constituents. There could hardly be a more vivid example of this phenomenon than the intense and prolonged resistance of the Yonkers City Council to the housing remedies ordered by the U.S. District Court in the case of United States and NAACP versus Yonkers, a decision which was recently affirmed by the Second Circuit Court of Appeals. In support of the court ruling, there is the well-documented record of city policies and actions over a period of many years which have had the purpose and effect of restricting the locational choices of blacks by maintaining racial segregation in Yonkers. In opposition, there are those white residents of Yonkers and their elected officials who maintain that the social and racial character of the neighborhoods in which they have chosen to live may not be compulsorily changed by the court. Less than a month ago, another Supreme Court decision found that the effect of exclusionary zoning practices by the town of Huntington, New York, has been to confine blacks to one limited area of the town, and that such zoning practices, whether intended to discriminate or not, are in violation of the Fair Housing Act. The court has ordered the town of Huntington to rezone a contested area in a white neighborhood to permit the construction of a previously rejected subsidized housing project in that area. Now, while the Yonkers City Council has agreed to comply with the court's order, and the town of Huntington appears also likely to do so, in the minds of many, questions remain which leave some of the most deeply divisive issues in these conflicts unresolved. There are not only questions about the nature and extent of the relief ordered by the courts, but questions as well about who among minorities is entitled to relief and who, in the public at large, must bear the burden of providing that relief. In both Yonkers and Huntington, implementation of the court's order will enable blacks and other minorities to obtain housing in areas of those communities in which they previously had no opportunity to live. It is entirely likely that many who obtain such housing have never actually sought to live in those areas, and consequently have never been directly denied the opportunity to do so. Is this relevant to their eligibility? If so, why? In the case of Yonkers, implementation of the court's order will require the expenditure of large sums of money from local tax revenues, revenues which, needless to say, would have been spent for other purposes in accord with locally determined priorities. Is this an unreasonable preemption of local authority? If so, why? These questions raise profound, equitable, ethical, practical, as well as legal issues, which are reflected in the persistent racial divisions which continue to characterize our metropolitan areas. Now, we have with us tonight 4 distinguished panelists, each of whom, in different ways, have been intensively engaged in the consideration of these issues. And I will introduce all of them before, if I can find my introduction of them, which seems... Thank you. Okay. I will introduce them not in the order in which they're sitting here, but in the order in which they will speak. Michael Sussman, who is on my left and your right, 2 seats away from me, is a partner in the law firm of Sussman and Sussman in Yonkers, New York, and is a specialist in civil rights litigation. From 1978 to 1981, he served as a trial attorney in the Civil Rights Division of the U.S. Justice Department, and from 1981 to 1986 was Assistant General Counsel in the National Office of the NAACP, responsible for a nationwide program of litigation concerned with housing, employment discrimination, and voting rights. And it was in that capacity that Mr. Sussman first assumed responsibility in 1981 for the trial and appellate work in the Yonkers school and housing desegregation case, a role he remains actively engaged in to this date. Linda Chavez, who is sitting immediately to my left, is a political commentator with wide experience in the print and broadcast media. Her views on national politics, foreign affairs, and domestic policy are a regular feature on National Public Radio's Morning Edition. In 1986, she made an unsuccessful bid for the Maryland Senate seat vacated by retiring Senator Charles Mathias. From 1983 to 1985, Ms. Chavez was staff director of the U.S. Commission on Civil Rights, and afterwards she served during 1985 as White House Director of Public Liaison, and in that role was the highest ranking woman on the White House staff. At the far end, to my left, is John Powell, who is currently Director of the National ACLU, with responsibility for supervising and formulating legal strategies and coordinating litigation nationwide. From 1979 to 1981, he was a legal services attorney in Seattle, Washington. In 1981, he became executive director of legal services in Miami, Florida, and was an adjunct professor of law at the University of Miami. And from 1984 to 1987, Mr. Powell was a professor of law at the University of San Francisco. And next to Mr. Powell, between he and Mr. Sussman, is Nathan Glazer, who has been a professor of education and social structure in the School of Education here at Harvard since 1969, and has been co-editor of the journal Public Interest since 1973. Professor Glazer's extensive writings on race and ethnicity are familiar to students of urban sociology both here and abroad. He has served twice on national urban task forces, first at the request of President Johnson in 1964, and again at the request of President Nixon in 1972. And since 1985, he's been a member of the National Academy of Sciences Committee on the Status of Black Americans. I will ask Michael Sussman to begin the discussion this evening. Thank you.
Thank you, Mr. Rabin, and good evening, ladies and gentlemen. My role tonight is to present to you, at least in brief, the facts and legal conclusions of the Yonkers case, and to explain to you the remedies which, in fact, in Yonkers are currently in place, being implemented by court order. In December 1980, at the complaint of the Yonkers branch of the NAACP, the United States Department of Justice sued the City of Yonkers, the Yonkers Community Development Agency, and the Yonkers Board of Education, contending that the city was responsible for pervasive racial segregation in housing and education. The novelty of the Yonkers litigation was, for the first time in American legal history, the municipality itself was being charged through segregative housing policies with creating racial segregation actionable under the Equal Protection Clause of the 14th Amendment in the Yonkers public schools. Extensive pretrial discovery commenced, which included some 150 depositions conducted over 2.5 years. These depositions were pretrial sworn statements taken of Yonkers city officials, as well as people hired by those elected officials to implement policies over a 40-year period in the city of Yonkers and at the Yonkers Board of Education. In August of 1983, we began what ended up to be a 92-day trial in federal court. The trial ended sometime in the fall of 1984. Extensive post-trial briefs were submitted by all parties, and in November of 1985, Judge Leonard B. Sand of the Southern District of New York issued a 600-page opinion, probably the largest and most extensively documented opinion in a civil rights case in American legal history, finding both the City of Yonkers and the Yonkers Board of Education liable as charged on all counts. The NAACP, the party that I represented in the lawsuit, intervened successfully in the suit in early 1981, certified our class as a representative of all blacks and Hispanics in the city, and later pleaded counts against a new party, the Department of Housing and Urban Development. In 1984, a settlement between the NAACP and HUD, the federal agency, was reached, reserving funds sufficient to construct 200 units of public housing in East or White Yonkers. With respect to that 200 units of public housing, the city of Yonkers in 1980 and 1981 had pledged that in exchange for receipt of federal community development block grant monies, it would produce and allow the construction of 200 units of assisted housing in white neighborhoods in East Yonkers. Between 1981 and 1984, no federal dollars were allocated for that purpose. The housing was not produced. The effect of the 1984 consent decree I negotiated with HUD was to ensure that monies sufficient to produce the 200 units and effectuate that condition would be made available. Early in 1986, having found the city of Yonkers liable for intentional racial segregation, Federal Judge Sand asked the city of Yonkers and directed the city of Yonkers to formulate and present to the federal district court a remedy plan which would in fact provide, as were previously for 40 years denied, housing opportunities to low and moderate income minorities as well as low and moderate income white persons in East and Northwest Yonkers. The city of Yonkers was given 3 months to devise a remedy plan, which was due in February of 1986. The city of Yonkers essentially produced no remedy plan. In April of 1986, a remedy hearing was held in which a school desegregation plan was worked out and fully implemented in September 1986. The housing side of the case lagged far behind, with the city essentially refusing, first, to produce a plan, and second, to implement the plan ordered by the district court in May of 1986 after a hearing regarding housing remedy. Now let me talk briefly about the essential elements of the housing remedy plan which were devised in May of 1986. There are two basic elements. Number one, the requirement that the City of Yonkers produce sites appropriate for the placement and construction of the 200 units of public housing, which Yonkers itself had agreed to construct, as I said earlier, in exchange for federal funds received between 1980 and 1984. The City of Yonkers was given 90 days to provide sites for that housing. No specific number of sites were required. It was left within the discretion of the city. The City of Yonkers refused to provide any sites for the housing and took a position directly contemptuous of the court order. This is in 1986. The second element of the housing remedy related to the development of housing opportunities beyond those for low-income people, rather directed to people of moderate income. The city was required by November 15, 1986, to develop a plan which would show how it would use its governmental authority to spur the development of housing for moderate income people in an integrative manner. By letter dated November 15, 1986, the City Council of the City of Yonkers contemptuously refused to present the plan and indicated to the court that it would not take any action whatsoever. In my judgment, this simply was a continuation of the racial politics which the district court had found permeated the City of Yonkers. It was clear that the refusal to implement or even devise a remedy was wholly the result of a politics dominated in Yonkers by racial bigotry, hatred, and intolerance, as well as the profound stereotyping of minorities who were perceived in the white community primarily as on welfare, on drugs, and otherwise entirely undesirable. After the November 1986 contempt by the City of Yonkers, the United States Department of Justice, with me a co-plaintiff in the case, moved for an order of contempt against the city. The NAACP moved both for an order of contempt, but also to appoint a person who would implement the housing. Our position was the vindication of federal constitutional rights was the critical value. Whether the City of Yonkers chose to implement or not was not particularly relevant to me or my clients. If they abdicated their governmental responsibilities, my position was and remains that they should be stripped of their governmental powers. They don't deserve them. They should simply be denuded of them. The federal district court took a different position, appointed a master to find ways to assist Yonkers in proceeding with the remedy. The master, in a 6-month period of time, indicated to the court that that was a useless endeavor and, in frustration, became simply the master accountable to the court and no longer working with the City of Yonkers. Eventually, sites were found for the 200 units of public housing. That occurred in January 1988, when after the special master, Mr. Newman, showed us that there were in fact sites available and identified those sites, the parties, in a consent decree which followed the affirmance of Judge Sand's opinion by the Court of Appeals, agreed to a consent decree, January 28, 1988. In that consent decree, there was an agreement on 7 sites for the housing, and there was an agreement by the City of Yonkers to pass an ordinance which would facilitate the construction of 800 units of moderate income housing spread throughout the city in an 80-20 configuration, using governmental bonuses and inducements to spur private developers to create affordable housing. The City of Yonkers was required by that consent decree to pass a zoning ordinance which would facilitate implementation of the consent decree. By August of 1988, the City of Yonkers, again through its City Council, showed a complete unwillingness to abide by its own agreement and went into contempt of court, the result being fines imposed upon the City of Yonkers and on the individual council members. At the point of bankrupting fines, the City of Yonkers on September 10th finally passed the enabling legislation allowing the long-term plan to be implemented. We're now at the point where the 200 units of housing are going forward with requests for proposals from private developers, and we're also at the point where a housing office of implementation is working to get private developers to build the 800 units in an 80-20 income mix, 80% of them being market housing, 20% being for moderate income housing. In my legal opinion, in my opinion as a person who studies these issues, these remedies are perfectly tailored to the constitutional violation in every manner appropriate, and it would be entirely impermissible to allow a heckler's veto, a small, rabid group of primarily white citizens who have clearly opposed and have been found by the court below, the Court of Appeals. The Supreme Court refused to even hear their appeal, to have been racist in motivation, and they remain that way in my judgment, to use pretextual arguments to defeat the rights of racial minorities to a reasonable remedy. I believe anyone familiar with the record in the Yonkers case, as the various judges who have reviewed that case record have indicated, would fully support both the liability findings and the patient remedy which Judge Sand has formulated and monitored. In my opinion, racial injustice must be fought through enforcement of the Civil Rights Act of 1964 and 1968, the constitutional provisions which extend protection to racial minorities. Any retreat from that, whoever is president, whoever dominates Congress, would be a slap in the face of the fundamental founding principles of this country. Now, in 10 minutes, that summarizes the facts of the Yonkers case as I understand them, the structure of the remedy, and I believe indicates the remedy to be entirely tailored to the exclusionary and discriminatory practices found by the district court and upheld on appeal. Thank you.
Thank you, Mr. Sussman. Our next commentator will be Linda Chavez.
Thank you. First of all, I'd like to step back a moment from the Yonkers case. For one thing, I don't presume to sit here and debate the facts of the Yonkers case with the one man in America who may know more about it than any other single person. But I think beyond that, there are some underlying philosophical issues and questions of public policy that are both more interesting and have more far-reaching implications than the actual facts of this case might suggest. I don't dispute that the Court of Appeals, in vindicating the decision of the district court, found that the city of Yonkers had engaged in invidious, egregious discrimination, both in the housing area and in the segregation of school children in education. I think it's fair to say, indeed the court did say, and by the way, the Reagan Justice Department said as well, that Yonkers was guilty of intentional discrimination. I'd like to discuss for a moment a hypothetical case and discuss the public policy implications of such a hypothetical case. What if no history of deliberate segregation in either education or housing existed, but rather a city was instructed by a court of law that it must put low-cost housing in places where no such low-cost housing had existed before? I think the underlying arguments in this case indicate that new rights were implied by the decision of the court. And I think those new rights, as they were implied by the court, indicate a direction in which we are headed, which raises very serious questions about public policy. Is there, implicit in the Yonkers decision, the right of minorities to affordable housing? Is an area deemed to be segregated simply because it does not mirror the representation of minorities in the larger community? If a city has 20% black population overall, must all of its neighborhoods also reflect such representation? These may seem far-fetched, but a look at the history and evolution of the goals of the civil rights movement suggests they may not be far off the mark. One way of assessing the Yonkers decision is to assess it in terms of the extension of the principles of affirmative action to housing. In looking at this issue from this perspective, I think it's important to step back yet another step and to look at the history of civil rights law in this country and to look at the evolution of that law as it has been interpreted by the courts, by subsequent legislative action, and by action of the executive branches. In the 1960s, when civil rights laws were drafted, they were straightforward and simple. They barred racial and ethnic discrimination in employment, in education, in housing, and voting. People knew what those laws meant. They said on their face that it shall be unlawful to refuse to hire or promote persons because of their race, their national origin, their gender. They said in plain language that it shall be illegal to refuse to sell or rent housing to persons because of their race or national origin. But court decisions and the later action of the legislative branch did more than simply enforce non-discrimination. Affirmative action was required to make up for past effects of discrimination, and those affirmative action rulings extended beyond the affirmative action that was required when federal dollars were given, for example, in federal contracting. Those decisions have been used to justify the impositions of goals and timetables to achieve certain percentages of minorities in the workplace, and have been used to create theories of underrepresentation in the workplace. They have been used to deny promotions to better qualified male applicants or male employees in order to promote minority or female employees. And perhaps more fundamentally than the concept of affirmative action has been the way in which the courts have defined discrimination. The fundamental expansion of the definition of discrimination to include acts that disproportionately affect minorities or women. In that regard, tests have been banned if blacks or other minorities have lower passing rates. In the Huntington decision, to which Professor Rabin referred, the lower court level used an effects standard for housing discrimination over the precise issue of subsidized housing. And even in the voting rights area, the Congress, the courts, and the executive branch have extended the concept of the right to vote regardless of race to an affirmative right of blacks and certain other minorities to have their votes protected in districting decisions to ensure their right to elect members of their own group. Again, the standard in voting rights cases to determine whether an act is discriminatory has been extended to mean discriminatory effect by the 1982 amendments to the Voting Rights Act. Therefore, any districting decision that has the effect of diluting black voting strength is open to challenge. These changes in civil rights interpretation are a far cry from the original intent of those laws. In the employment area, one has only to read the legislative history to see quotes by Senator Humphrey and others that if the law were ever used to grant preferential treatment to minorities, Senator Humphrey promised that he would eat the pages of the law in front of his colleagues. In education, we have come a long way from a decision which allowed a young black girl in Topeka, Kansas to attend her neighborhood school, which was an all-white school at the time, to plans that have required busing over long distances and across jurisdictional lines. In the voting area, we have come a long way from obstacles to blacks, from registering and voting, to requiring that districts be drawn so as to ensure large enough percentages of black voters to ensure that a black official is elected. And in the housing area, we have come a far cry from barring the denial or sale or rental to blacks to the Yonkers decision, which requires that low-cost or subsidized housing be placed in areas where it did not previously exist. Perhaps the ultimate irony will come when the goals of civil rights organizations clash in the voting and in the housing areas, because in many ways these goals are mutually exclusive. As housing patterns become less segregated, black voting power will become diluted. Judging from the experience of the last 25 years, one need not be a cynic to suggest that when that time comes, the term gerrymandering may take on a whole new aura of respectability, much as the proponents of affirmative action have taken that term the long distance it has come from 1964.
Thank you. Our next speaker will be John Powell.
Ms. Chavez thinks that the court has done too much, and I dare say that Mr. Glass will probably agree with that proposition. I think the court has done too little. I think the basic way to approach the problem, though, is not simply enter into an argument as to what the court has done, but to look at what is it that we're really talking about. The topic tonight is really focusing on affirmative remedies and the role of courts in adjudicating those remedies. The model that is oftentimes offered as the appropriate model for the role of the court and as the appropriate model for the role of adjudication is a model that has some currency as one model, but is totally debunked as the sole and only model. And that model is two individuals, two private citizens coming before the court with a private concern in which the court, as a neutral and passive umpire, decides the rights of those two individuals. That model suggests that the role of the court is to, first of all, find out what agreement and expectations existed between these two private citizens, to find out who is the wrongdoer in setting out these agreements and expectations, and to make the party whole. That model has never been as expansive and as universal as some would have us to believe. And today that model plays a less and less importance as we look at constitutional law and specifically issues dealing with race and discrimination. Affirmative remedies is what happens in the area of public law. And public law is not simply concerned between what happens between two individuals, but it looks at relationships between groups. It looks at relationships between individual and large institutions. And in public law, the role of the court is not simply to correct the status of the two parties before it, but it's in part to interpret and give meaning to public norms and constitutional values. Values such as liberty, values such as equality. And any student of the Constitution knows that while those values are explicitly mentioned in the Constitution, they are not defined. Some would have us re-debate Marbury versus Madison, but that has been a doctrine that has long been settled. The body in our constitutional democracy that is given the charge to interpret the values set out in the Constitution, the norms in our society, is indeed the court. And the court is given that role because the court is independent and because the court is charged specifically with adjudication. When you approach this model, this second model, along with the first, then you see two different functions or two different forms for the court. One function deals in the area of private disputes. The other deals with the area of public disputes. As we have moved more and more to a regulatory society in which large institutions play an increasingly important role in our lives, it's not surprising that public law also has a more important role in our society. The dispute between individuals is oftentimes a dispute of interest. The dispute in public law is oftentimes an issue of value and rights. In coming up with remedies in individual cases, the courts look retrospectively. They look for an individual wrongdoer. Therefore, you have the intent doctrine. Did you intend to do the logical consequences of your acts? In public domain, intent is not as important for a number of reasons. The court is not simply trying to correct injury by an individual. The court is trying to correct a social condition and to make public pronouncements. And in our society that has had, at best, a spotty relationship with the concept of equality, the court in 1954 decided to take on the issue of indeed giving equality substantive meaning in our society. But the public interest aspect of law is not something that has been developed just for the benefit of race. It is not something that was developed in the 1950s in Brown. It's something that existed over 100 years ago. This country was completely reshaped in terms of railroads through the courts, breaking up large monopolies. Environmental law involves issues of public interest. Antitrust law involves issues of public interest. Bankruptcy. And as Professor Rabin mentioned early on, a number of civil rights issues deal with concerns now of age, of gender bias, and other areas. But it is race issues that sticks in the craw of the society. It is race in which society has been most intractable in terms of dealing with. And this issue of race, when the court started addressing these issues, that the issue of the legitimacy of the court is called into question. The court has a limited role, but it also has a powerful role. The role is indeed to give broad pronouncement. The court need not find a wrongdoer in order to correct social conditions and to give meaning to constitutional norms. Neither does it have to have a fit or a tightly tailored fit in terms of the beneficiary of those doctrines. When Linda Brown, in the Brown case, sued, she was not suing in her own behalf. And the court was not trying to correct an injury just between her and one other party. It was trying to correct a social condition that required expansive reorganization of our school systems throughout the country. And in doing that, the court also recognized that it was not just concerned with what had happened in the past, but it was looking to the future. It was not just retrospective as an individual litigation, but prospective. Now, for all of the things the court had done, and for all of the efforts the court had made, Linda Brown's daughter still goes to school in Topeka, Kansas, in a segregated school situation. The city officials of Topeka, Kansas, as in other areas, in Huntington, as in Yonkers, continues to be recalcitrant. The court has a role and obligation to deal with recalcitrant city officials. And how it deals with it is a question that we could debate. It may not be dealing with it in a way that some people would think is the most efficient or the most effective. But in our constitutional democracy, the court is the body that is given that responsibility. And in discharging that responsibility, all of us then can sit around and second guess the court. Finally, let me say that whether or not one finds intentional discrimination or not seems to me to be a poor test in a society that was born with equality on its lips, but slaves in the farm. In a society in which 30 years after Brown, 40 years after Shelley, blacks in society continue to be segregated in schools and in housing. It's not simply a vague pronouncement, an abstract right. We have to remember that the Civil War amendments were passed with specific concerns in mind. Those concerns have still not been addressed by the court. And as the court continues to try to address those concerns, it is not remarkable that there will be tremendous outcry about the legitimacy of the court's role. Thank you.
Thank you, Mr. Powell. Our next speaker is Professor Glazer.
I think we had a masterful exposition of the facts by Mr. Sussman, using illegal terms, which I'm not entitled. I will stipulate to all of them. That's the story, more or less. Let me quote something Governor Cuomo said on August 5th while in the middle of one of the many crises around Yonkers, while the city councilmen were being assessed fines and the city was being assessed fines. He did come into the case late and was properly criticized by the New York Times for that purpose, for that reason. Asked what he would tell Yonkers residents who opposed the plan, the governor said, "Before you speak, you'd have to let them talk about the fight, about how their houses are all they have, about how the value of their homes has now gone down, about how the kids are frightened. It is wrong to tell them arrogantly, 'You've lost, you're wrong.'" The thrust of his comments was that Yonkers should try to persuade Judge Sand that perhaps another plan spreading out the low-income units could be devised. That's a quote from the New York Times. Now I have a few other quotes from the New York Times which I know are somewhat sensational, but the Times does not go into sensation, and I am reading them in order to fulfill Mr. Cuomo's injunction, before you speak, you'd have to let them talk about it. Well, we'll let them talk about it. This is what they say, according to the Times correspondents, who are always equally balanced and, report both sides and so on. So here are a few quotations. Julia Troy, who is 83 years old and lives several blocks from one of the 7 sites proposed for 200 units of low-income housing that the city has agreed to build. 7 sites for 200 units, a mere maximally 30 units there, said she would rather see the city go bankrupt rather than face the drugs, crime, and blight that she believes public housing will bring. On the fringe are voices that are violent and rabid. Times reporter quotes someone who says, "There are things that can be done, like blow it up." Well, this sort of thing happens in New York, elsewhere. They burn down houses that are supposed to be to help the retarded or to succor babies with AIDS and so on. They get built again, but they do that. Jean and John Liggio first walked through their front door on Helena Avenue 14 years ago after fleeing a Bronx that was declining. Across the street from them is an overgrown half-acre that is now designated for 22 units of public housing. Who would object to 22 units of public housing as against an overgrown lot? Well, they do. "We worked and saved all our lives so we could move out of the Bronx to this beautiful neighborhood, and for what?" said Mr. Liggio, a 62-year-old automotive supplier. "So we won't be able to sell our house. Its value has lost $100,000. While many residents acknowledge that most of the present public housing in Yonkers has been confined to the southwest corner, the basis of the case, they quickly counter that the city has 6,800 units of public and subsidized housing. In a city of 200,000 people, and I suppose something like 50,000 units of housing. "You find me a black family," the Times quotes someone, "in Tuckahoe or Scarsdale or Bronxville. The only reason Yonkers is in this soup to begin with is because we let in projects in the first place." Well, the reporter goes across town, and at Schlobone Houses, a decaying public housing project in southwest Yonkers. The residents said they had concerns more pressing than the city council's defiance. "Right now I'm trying to get the drugs out of the building," said Mabel Hendricks, who has lived at the project for 17 years. "It's not going too well. They've been selling drugs in the hallways here all day." The news story I'm quoting from ends with the following: "To Mrs. Hendricks and her neighbors, there isn't any doubt about what lies behind the opposition of residents on the east side of the Sawmill River Parkway to public housing." It's a very ironic ending, and as you know in news stories, if any of you have worked on newspapers, when you don't run out of room, you cut off the last few paragraphs, just keep on knocking it off from the end. Unfortunately, with this ending, after discussion on drugs, what is the answer? What are they objecting to? Are they objecting to blacks or objecting to drugs? I have some more, and maybe I will quote a bit more. Yonkers lies in the shadow of the Bronx. Bronx is very well known, not only to readers of the Bonfire of the Vanities, but all moviegoers, readers, television viewers, readers of the press. It is just to the north. And here's another story. The reporter goes there. He's working both sides again. Here's Mrs. McLaughlin, her husband Patrick, their 4 sons in the Dunwoody section, a street lined with Cape Cods, and their Catholic churches and Italian delicatessens. The neighborhood is only 15 minutes from the South Bronx, from which our family fled with other whites 20 years ago. Fled? Well, I can well imagine if the sensitive editor would say, shall we let us say fled, when they no longer felt secure on one's familiar streets. And then the reporter is sitting in on a conversation. 3 neighbors, all of us have worked for our homes, Patrick McLaughlin said. Our houses are our major investments. We're not anti-integrationists. Show me some black guys who are working, and I'll go out and get people here to sell them houses. Whether he would or not, I don't know. That's what he said. But we don't want any free rides. We're talking about a subculture of poverty. Sounds very sophisticated. Study sociology. The crime-ridden, non-working poor, people with lesser values that we don't share. The McLaughlins sat at their dining room table with 2 friends, Jerry Longarzo and Bob Gouldner, talking about the judge who says Yonkers must build low-income housing in their neighborhood. They talked for hours about their lives, their homes, and their fears. They are solid citizens. Mr. McLaughlin, who I've just quoted on the culture of poverty, is assistant chairman of a committee on the handicapped in a community school district in the Bronx. He knows what he's talking about. It should, something. Mr. Longarzo is assistant principal at a Bronx elementary school. Mr. Gouldner is retired from the New York City Police. A lot of these people who are carrying on in Yonkers are people who came from the Bronx and still work in New York. Policemen, teachers, and this chairman of committees in the handicap. Around the table, the issues of public housing and civil rights seemed inseparable from their own experiences. When they talked about discrimination, they talked about that suffered by their immigrant parents. When they talked about housing, they talked about how hard they struggled to buy their homes. I must say this is probably more than we need. And then the reporter points out they believe that the decay of the Bronx stands as one of the principal experiences of their lives, seeming to inform all of their fears about low-income housing. We could see the projects going up from our kitchen window, Mr. Gouldner said. I remember my mother saying that's the end of the neighborhood. The reporter points out other people say there were other reasons for the end of the neighborhood. Well, that's enough of that. But I was following Mr. Cuomo's injunction, the Governor Cuomo's injunction, a man we all admire, to say listen to their voices. And there are other voices, the people in the projects, middle class blacks living in Yonkers who are outraged that no one has spoken up. I could have quoted from that, but I only have a few minutes. Now I speak in my own voice, tentatively and briefly. So what do we draw from all this? The people of Yonkers who are opposing the plan developed by the judge's housing expert, Oscar Newman, have a point. They escaped a very bad urban scene. They worked hard to escape it. They are angry that in those communities in which no public housing has been built at all, in which there were no poor and working class people to house to begin with because housing was too expensive, there is no case. They see themselves the little guys, the ones who are expected to bear the onslaught of terrible urban problems. Are they racists? They're reacting on many grounds. They don't want to see the values of their homes decline. They don't want to see an influx of people on welfare and of single-parent families. They don't want more crime and juvenile delinquency. And yes, they don't want blacks. Undoubtedly, there is a sophisticated statistical technique by which we could determine the contribution of these and other factors to their resistance, and we might even absolve them of racism. But the fact is you can't impose low-income housing on people against their will because they fear crime and drugs and don't want to live near welfare and single-parent families. That doesn't make a constitutional case. You can only impose low-cost housing on them in federal court if they have been convicted of discrimination on grounds of race. That's the only case you can make. So race, which may be 10% or 50% or 90% of the reason they oppose public housing, becomes the ground of legal action. And the only way to get public housing in the areas that resist it is to prove in federal court they're all racists. That's a great way to produce social peace, but nevertheless the only way to do it, because the only way to get action is to prove they're racists. Now, one cause of this complex situation has been brought into court, race. for that is the only cause on the basis of which the judge can act. The action he demands is most reasonable. I agree it is. There aren't going to be huge projects, but townhouses, 207 sites, 30 in each, so how can that be a problem? The people fighting it may simply be too irrational to be convinced that this can't hurt them. Oscar Newman, the judge's expert, says that they would be right to be upset if they were big projects, but these can't hurt them unless they panic. On the other hand, they may not panic. How do they know their neighbors won't panic? 30 families across the street on 2 acres, it's a problem. Governor Cuomo says, talk with the people, try to understand them, see if you can allay their fears. But that isn't a judge's role. A judge's role doesn't talk to people and allay their fears. He decides the law is, Mr. Powell just pointed out. And really, that's been no one's role in the Yonkers case, to allay their fears. It's one of the problems with legal action, the adversary system. The Yonkers councilmen don't play this role. If they even try to talk to the community, they lose their seats. Why talk? The state politicians haven't played this role. There's no benefit in it for Governor Cuomo, or Senator Moynihan, or Senator D'Amato. 1 minute is enough. So they don't get involved. The situation looks pretty bad, and I wondered if I just end here, but I do have a minute. But there is a kind of learning that is going on in this situation that I think may help in the end. It is very slow. I mean, a general learning. Consider that this case began, and no one's mentioned it much, except Mr. Sussman, in the last days of the Carter administration as a school segregation case. If this case had come before Judge Sand 5 years earlier or 10 years earlier, there is hardly any doubt what he would have done. He would have imposed a busing solution. A lot of trouble. Well, after Boston and other places, we have learned that's not a good idea. And when it came to the school desegregation part of the case, the remedy, I understand, and not without conflict, of course, but it seems to be implemented, is magnet schools, and that sort of seems to be working. There's been learning on the housing side, too. Judge Sand didn't impose another Schlobohm houses in East Yonkers. Mario Cuomo in the early 70s solved a similar problem in Forest Hills by reducing a 700-unit project to 350 units, reducing 24-story buildings to 12-story buildings. That won't get you very far in Yonkers. In Yonkers, 7 stories is high-rise. In the late 1980s, everyone agrees 12 stories was too high probably in Forest Hills, and 7 stories is too high in Yonkers. I think there is learning going on, and I wish it had proceeded to the next stage down, so something like I would prefer vouchers for families to try to seek housing in their own, using the full protection of anti-discrimination law. I have a quotation on a similar case, the Gautreaux case in Chicago, which in the end ended up that way, a kind of assisted moves to the suburbs and so on. It seems it hasn't done too badly. My point is there are real fears, and they are based on real things. And I simply don't see how we're going to get very far by hitting the people of Yonkers on the head and saying, we won, you lost, and now take it.
Thank you, Professor Glazer. Begin immediately after these responses by the panelists, and I'd like to first call on Linda Chavez.
Thank you. Well, I guess we're supposed to respond to each of our colleagues up here, and let me respond first to Mr. Sussman. I think it was quite possible to bring a case against Yonkers that dealt with the specific issues of school segregation and that dealt with intentional discrimination in housing that did not include the placement of low-cost housing in non-minority areas. The city of Yonkers, in fact, did engage in discrimination in its use of Section 8 vouchers. Minority persons were steered into minority sections with those vouchers. There was a misuse of those vouchers, a segregative, illegal, discriminatory use of those vouchers. And I presume that there are also other instances of persons within the city of Yonkers, real actual parties who attempted to move in to predominantly white areas who were denied that opportunity. And such a case could have been brought and could have been resolved satisfactorily, I would not have had any objections. Likewise, I think in terms of the segregation case in the schools, I think the judge's decision was a fair one. I think there was a clear case of intentional segregation that was perpetuated for decades in the Yonkers school system. In regard to what Mr. Powell had to say, I think there are two areas in which I disagree with him. One is that I don't believe that it is simply the courts that are culpable in this vast expansion of affirmative action into areas beyond employment. I think the legislatures, the Congress of the United States has been culpable in this respect. I think the executive branch has been certainly culpable. The Reagan administration, which has taken tremendous criticism for the last 8 years for having supposedly rolled back the clock in affirmative action. In fact, President Reagan, when he had the opportunity to rewrite the executive order 11246, which controls affirmative action in employment in the private sector, chose to do nothing and to leave in place not only the executive order, but the rules and regulations which have been interpreted even under the Reagan administration to require goals and timetables in employment. I also disagree with Mr. Powell with regard to whether or not we can have a definition of equality under our Constitution. I think most Americans understand what equality is, and it is most explicitly not equality of results. I think the equality of opportunity is what can and should be guaranteed under our Constitution. I think it is that equality of opportunity that is guaranteed by our civil rights laws. And finally, in response to Professor Glazer, I would simply add that it is no accident that this instance occurred in a working class area. The burdens of affirmative action have disproportionately been borne by working class people. It is, after all, police and fire departments and civil services that have been the focus of much of the effect of affirmative action decisions through our courts. You do not see affirmative action in corporations to the degree that you see it in municipal employment. Thank you.
Thank you, Ms. Chavez. Mr. Powell?
Thank you. A few comments. First of all, it was suggested that there's I think some mixing up and frankly some confusion between issues of poverty and issues of race. This is not an issue of class. This is a case about race. It's explicitly a case about race. The Yonkers case, the Yonkers situation started in the 40s, at least in the 40s, if not before then. At that time, people were not selling crack on the street. There was no issue of crack, and yet the Yonkers citizens and the Yonkers City Council in the 40s did everything they could to prevent blacks and Hispanics from moving to this area. Secondly, in terms of the issue of class, the court could not order low-cost housing built in every community. That is true. But the corollary is not true. That is, private citizens do not have a constitutional right not to live in a neighborhood where there's low-income housing. The Congress could pass a statute, and we're talking about statutory provisions because we're talking about Title VIII. We're not talking about simply the Constitution. The Congress could pass a provision, or any state could pass a provision calling for inclusionary zoning, which would mean that low and moderate income housing would have to be built in every neighborhood. It would not violate any constitutional right of a citizen. There is no right, and Ms. Chavez, who's very concerned about generating new rights, there's no right of people not to live, of people of economic status, different economic status in this country. Finally, if we look at some of the justification and some of the confusion, there's what I call a cycle of excuses. People explain education segregation by housing. So we don't discriminate. We just have neighborhood schools, and our neighborhood just happen to be all white. And then you say, well, why is the neighborhood all white? It's not because we discriminate. It's because in order to live in this neighborhood, you have to have a lot of money and get good jobs. And black people just don't have those jobs. And why don't they have those jobs? Well, in order to get those jobs, you have to go to a good school. And it just happens they don't go to those schools. And the cycle continues. And anything but race in a country which history is just replete with explicit racism, a country whose greatest war was the Civil War, and in terms of per capita, the greatest casualties, much more than World War II, was fought over the right to keep people enslaved. Now all of a sudden, race is going to be pushed off of the agenda, and any other excuse becomes fine. There are real concerns, but it's not simply the concerns of the people in the neighborhood. It's also the concerns of a whole society that does not come to terms with race in this country. There are a number of creative ways of dealing with this issue, and I don't want to suggest that there aren't some legitimate concerns for the neighborhood. For example, in Chicago, they've instituted a plan where they have insurance, and as your neighborhood becomes integrated, the property value is insured. That's fine. I mean, these are social issues. They're larger than the community. I don't care how you resolve them, but you can't use those concerns as a veto for dealing with race issues in this country.
Thank you. Professor Glazer.
I'm going to cede at least 2 of my minutes to the audience, which has been very patient. But I'll just make one comment on this notion of a kind of social learning, or a change of remedy and so on, as in the case of school desegregation from busing to magnet schools, and I think there's a general pattern that way. And in the case of housing, I think there is a strong feeling, and I think this is one issue, that we don't want to dedicate bricks and mortar eternally to the poor. I think the whole idea is a lousy one. The idea that now we're going to have 24 units of housing here across the street from you, and you can be sure that poor people will live there forever. That is what it means to build housing that is earmarked for the poor. There are better ways of dealing with the housing for the poor, which gets us into an awful lot of things. And I think that even though we had reduced the project size radically, it was still the notion of the brick and mortar eternal dedication that was a very difficult thing to take.
Well, Professor Glazer, I must tell you that I think your analysis of the Yonkers situation is about as far from accurate as any I've heard. The issue in Yonkers is one that's very simple. People have used every pretext imaginable to hide an unbelievable and acerbic racism. Now, you talk about housing vouchers. The consent decree with HUD calls for an expansion of housing vouchers by 175. You know how many of them are being used integratively? 2. You know why? There's no housing supply in white areas which people with housing vouchers can use. So how do housing vouchers expand housing opportunity in that context? They don't.
I think we need to give the audience some opportunity at this point to participate.
I haven't gotten my rebuttal yet. Isn't my rebuttal?
Oh, I'm sorry.
Excuse me.
I'm sorry.
Now, you mentioned Mario Cuomo, who you apparently take guidance from. Mario Cuomo's first comment about the Yonkers case, as you concede, was 8 years after its instigation, 3 years after the decision by the district court. You know what his first comment was? There's no discrimination in Yonkers because Harry Belafonte and Lena Horne can buy a house in the white neighborhood. You want to adopt that comment as well? You talk, Ms. Chavez, about the working class and the fact that Yonkers is a working class community. East Yonkers is not a working class community. The predominance in East Yonkers is middle class and upper middle class living in rather expensive homes. It's not a working class community, and it's not an imposition on the working class. Several of the sites are specifically in neighborhoods where homes are $400,000 a year. You can't have it both ways and say you're at once imposing low-income housing on people who have great incomes and also say this is an imposition on the working class. That's nonsense. Now, the Reagan administration's role in this lawsuit was one of support. Yes, give you credit for that. But the Reagan administration has done nothing in 8 years in civil rights except advocate, with your insistence, the rights of white males. So to speak about the Yonkers case as anything but an anomaly in the Reagan administration is totally inaccurate. Now, let's get to a couple of other arguments that have been raised. I have another minute and a half. I'm keeping track. You say, Ms. Chavez, a number of things about affirmative action, and it's gone too far and it's gone too far. Why then, with William Bradford Reynolds, William French Smith, and the Justice Department with 500 lawyers advocating repeatedly for retrenchments in civil rights over 8 years, have you not won one victory in the Supreme Court of the United States, many members now you've appointed? You have tried repeatedly to get a conservative Supreme Court to retrench on these civil rights, and they have refused, and they have vindicated every extension which you criticize. Now, what I hear from you, frankly, is the same kind of lawlessness I hear from people in Yonkers. This is the law, but we don't like the law. We complain whenever it benefits racial minorities. And that's the point Mr. Powell is making. We can have an activist court on every issue, but we have great objections when the activism benefits racial minorities and deals with the despicable racial history of this country. We as white Americans better deal with that and better dedicate our lives to getting beyond that so our children don't have to. Thank you.
I hope not unfair, but at the risk of attempting to summarize, let the audience respond to what seems to me to be two really diametrically opposed points of view. One being that the evidence which was adduced in court warrants the imposition of a remedy, however opposed that remedy is by the people who live there. The other apparently being that the views of the people who are affected by this remedy must be seriously considered. And let me know if I'm unfairly stating this case, that somehow the views of the majority, views which for years have been translated into public policy by elected officials in Yonkers, must continue to be given some considerable weight in determining whether the relief ordered by the court should in fact be imposed. Okay, what we will do is alternate between the microphones, and please step right up, try to make your questions brief, please. Again, no speeches, and speak directly into the microphone. Yes.
Hello. My name is Monica Stewart. I'm a student here at the Kennedy School. And Professor Rabin, I understand your admonition about speeches, but I would like to remind Linda Chavez that, as President Reagan said, facts are stubborn things, and we can't ignore facts. Slavery was a fact. The people who were enslaved were not, in fact, in point of fact, were not white Americans. And these are facts that have shaped the history of discrimination in this country. And slavery was a fact from which racial discrimination, I think, has flowed. But my question is to Professor Glazer. I found it interesting that after reading newspaper accounts, you commented on whether or not social learning had taken place and the quality of the learning. And I would argue that how in the world can social learning take place? And I would say that obviously very little has taken place when political leaders, educational leaders are quick to, rather than face the ugly issue of race, would instead apologize for it. When Cuomo, I'm glad Sussman brought up the point that Cuomo said, well, Lena Horne and Harry Belafonte can move in that neighborhood. Well, Bob Hope and Lucille Ball could move into any public housing project, and I'm sure their neighbors there wouldn't mind it all either. But, and also you refer to the control decision. And in point of fact, that a panel at the University of Chicago just released last week an amazing finding that race is still a determining factor in housing in the suburbs. Now, I wonder, I said they paid money to people to discover this startling fact. And also, they took a look at race, and they took a look at the Hispanic community, and they found that if a Hispanic person or family looked black, then they received the same treatment as black Americans. If they looked white, if they looked white but spoke Spanish and had accents, then they received a lesser amount of discrimination.
Could I, since it's addressed to me, and I think we've gotten the point, now let me say something. I'm getting a little tired of being called an apologist for racism, and I will speak up on that. 10 years ago, 15 years ago, I told everybody in Boston, you are stupid on this silly busing for school desegregation. Everybody in Boston now agrees with me. The whites, the blacks, the school commission, the lawyers, and everyone else. So don't go off on this business. I don't like it that one is trying to deal with a serious social problem to say you're apologizing for racism.
Well, those of us,
I am not apologizing for racism. Shut up. I am telling you what these people are afraid of.
Shut up. And I think that there are those of us who also are tired of a lot of things, of the fact that we cannot come to grips with this problem. And what my point was that white Americans don't make class differentiations, which is what you were saying, and that simply does not happen with regards to white perceptions of the black community.
These mics are. I think that the key point that hasn't been brought up tonight, but that seems to corroborate your point, is that in the Yonkers case, as in so many other cities in the United States, whenever HUD does a study of private market housing discrimination, what's found is a tremendous and pervasive discrimination against middle-income blacks.
Oh, fight it.
Hold on.
Fight it. You can't fight it.
Why don't you fight it? I've been fighting it. Now, wait a minute.
Why don't
the
you
issue,
fight it?
I have been fighting it. And
excuse me,
public housing, people would
discrimination against middle-income blacks?
Public housing recipients.
Move into the
Why don't
public
you let someone else answer? Is your only way of responding to filibuster? You asked a question, let someone answer the question. Now, the basic point as to why we're doing what we're doing in Yonkers is because there is a despicable history in Yonkers of isolating low and moderate income minorities in a 1 square mile quadrant where 7,000 units of assisted housing were built, and a correlative and reciprocal history, despite 80 proposals to build the housing in white neighborhoods, of not allowing it there. That's why we're fighting that. Now, the key point, though, that corroborates what the young woman is saying is that there is a close connection and nexus between private racial segregation and its expression in public policy. That's what the Yonkers case is about. The public sphere reflects private sentiment. And the private sentiment is what has kept blacks out of the housing in East Yonkers. The white realtor, who is the biggest realtor in Yonkers, the former head of the Yonkers Board of Education, testified at trial that when he tried to sell houses to blacks in East Yonkers who could afford them, he got threatening phone calls before he returned to his office repeatedly. This is in the late 1970s, and it persists to this day. And that is being fought discreetly in suit after suit. The key point is what it reflects about the public process, public policy.
We'll take a question from over here now.
Yes, sir.
The very first night there, their home was firebomb. Fortunately. against physical violence in Yonkers before it occurs, before Yonkers makes Howard Beach look like a love fest?
The answer to your first question is that there has been a deep and sustained concern that violence will erupt. The Federal Bureau of Investigation, which people can have differences of view as to how effective they will be, has been already conducting the kind of surveillance and activity that you intimate to try to determine those most likely to instigate such violence, to isolate them from the community, and to surveil them, essentially, to determine what they're doing. So, yes, there is a need for very great vigilance with regard to that issue, but I have said publicly many times in Yonkers and outside of Yonkers that the threat of force cannot be a deterrence to us who are trying to vindicate fundamental rights. Just as the naysaying that we hear on the panel as to why not doing this, why not doing that, that can't be a deterrent. We have a clear finding and adjudication of racial discrimination, and that must be remedied. That's the law of the land, and we cannot let those who would raise the stakes of the sort that you intimate about to deter that. And we're going to take every step imaginable to prevent it, including all those you mentioned. And the court is well aware of this problem and is prepared to intervene and has already directed the FBI to be quite vigilant.
Well,
I'm sorry.
first of all, I think there's no doubt at all that acts of violence that are racially motivated must be punished, and they must be punished aggressively. And yes, I would support the use of whatever legal means available to punish those that are involved in those acts. But I, like Nat Glazer, resent the implication that because I view equality of opportunity as the guiding principle, and because I oppose some of the methods used by courts and promulgated by our Congress in the affirmative action area, that I somehow condone racism. I lived for 12 and a half years in Washington, D.C. in a predominantly middle-class black neighborhood. I chose to rent there, and I chose to buy 2 homes there. And my middle-class black neighbors went absolutely berserk when the city of Washington decided to try and place a drug treatment center in our neighborhood. The community was organized. There were threats of near violence until a change was made, and that project was not placed in that middle-class black neighborhood. Reaction to low-income housing because of the concomitant problems of crime that are associated with housing projects is not an unreasonable fear. And I do not believe that we can simply impugn the motives of all of those who oppose those low-income housings on that basis. Some of those who oppose them are racist and are racially motivated. Not all who do are.
The next question we're going to take is up on the upper level and then over to the other side. Yes.
Yeah, Harbor Point here in Boston, South Boston. We at the Kennedy School have studied it, looked at it. Are you anybody on the panel who's familiar with that? That's a mixed housing of low and medium income families. Is that a reasonable solution to the problem as you've all described them tonight?
The bulk of the housing remedy in Yonkers numerically, the 800 units, is to be configured in 80-20 housing built by private developers, 20% being for low and moderate income people, and an income distribution set forth in the consent decree, 80% for the market. My own personal preference would have been to collapse, in fact, all of the assisted housing, including the public housing, in such a mix. HUD vetoed that idea and said that they would refuse to pay if the public housing were in fact incorporated in a broader vertical income mix of housing. I do think you're right to suggest those kinds of mixes as preferable to freestanding public housing. And in September, when we sort of renegotiated at the point the city was going bankrupt, some of the provisions, I was prepared to go along with that, at least to a limited extent. The federal government was not then prepared.
Let me just add one thing to your comment, to that question. There was a suit in the 70s out of Pennsylvania, Shenandoah, where HUD wanted to build additional low-income housing in one area. They were building all the low-income housing in Philadelphia in one area, and the suit was involved, and I was involved in a similar suit in Seattle. At the time that areas were called impacted areas, basically saying you can't build all low-income housing in one area. So as a remedy, I don't think anyone would disagree that there are better models than building these giant, 2,000-unit homes next to single-family homes. And I think in the long run, I don't know if we'll ever get to this, but the idea of inclusionary zoning across the country so that people have no place to run is the way to go. And also so that the houses that are built and owned or occupied don't stick out as a sore thumb from the rest of the neighborhood, I think makes sense also. But that also means tremendous dollars appropriated by the federal government. And this federal government now, as you know, have been cutting back federal dollars for all types of housing.
Yeah, for those of you who are not familiar, the Columbia Point development that was referred to above is really significantly different from Yonkers in the sense that what you had there was a very large public housing project, which is now being converted to a mix of market rate subsidized and low-income housing without really significantly increasing the number of housing units that are there. So it's in many ways almost the reverse of what is taking place in Yonkers. Yes?
Yes, this question is essentially a follow-up on the previous question. Given that racism existed in Yonkers, and I believe Ms. Chavez and Mr. Sussman are in agreement on this, what can we take the experience of Yonkers for as a lesson in the future? How do we approach experiences in future Yonkers to avoid the fraction that occurred in Yonkers, if indeed that fraction is avoidable?
I think each member of the panel perhaps ought to try to briefly respond to that question. What do you do?
Well, again, the thing that I'm obviously pushing tonight is that if New York as a state was to decide that, and it could do this, that every neighborhood would have to build its fair share of mixed housing, and there's no constitutional right that would move us a long way, and there was money available to help that. That would move us a long way. One of the things that the citizens of Yonkers complained of is that while they were being forced to take subsidized housing and public housing, other neighborhoods were not. So that's one thing that I think that we could do. The other thing, though, I think is that we have to have some leadership from different parts of the country really making it clear that this kind of veto is not tolerated in this country. And right now what we have is, at best, ambivalence, and at worst, siding with with those communities by the leadership in this country.
I keep on thinking of what, clearly the Yonkers case, yes, that's the law. It should be enforced. I'm glad Mr. Sussman is doing everything he can, and all these people who are firebombing and threatening, and they should all be thrown into jail and worse. And we all agree on that. And if they can find them, and whatever efforts are necessary to find them, wherever this, there's no argument about that, and I would hope it would be very severely enforced. Nevertheless, one thinks about potential alternatives, and it occurs to me one other thought that hasn't come up here, or, if it's been a thought involved, is that one of the ways, it refers to this mixed program at Harbor Point and other mixed developments we've had in Massachusetts, and I would think a key element there is something which creates problems for other lawyers, and that is a very severe selection policy and a very severe ejection policy. One of the problems of public housing has been that it has been very hard to, because of various rulings and complications, to select people, and it's been very hard to throw them out. I think that once it comes to mixed units, they can only succeed if this power exists and is exercised.
I think the thing you have to come to grips with is that all through the United States, you have huge waiting lists among low and moderate income people for housing. In Yonkers, there's a waiting list for public housing of 1,200, in moderate income categories of 3,000 families in a city of only 200,000. Westchester County has 5,000 homeless people, which is per capita the highest rate in New York State. the idea that certain neighborhoods have the right to exclude implies directly that the people who are excluded go to other neighborhoods and must be accepted in other neighborhoods. We don't have the moon as an option to put the people on. So I think that fundamentally what we have to deal with is that if you oppose the provision of assisted and affordable housing in white neighborhoods, either you only favor the provision of that housing in extant minority neighborhoods, or you disfavor the provision of the housing altogether. Now, Professor Glazer said that people don't want to see housing just for poor people, identified forever for poor people, bricks and mortar for poor people. Well, what are we going to do? We get poor people in America to house, probably 30 million of them. So we can't simply adopt a policy that acts like they don't exist. They exist, and they've got to be housed, or they're going to live in Grand Central Station. And we don't have any politicians in this country, to my knowledge, any that I've heard, who acknowledge it and come up with a policy for it and say it's got to be done. And it's got to be done, period.
Chavez?
I think there are other alternatives to the provision of public housing. I think the idea of providing people with vouchers in order for them to go out and be able to purchase their own housing is a far better alternative. We are spending now in welfare hotels in New York and surrounding New Jersey suburbs and in Washington, D.C., in excess of $30,000, $40,000, $50,000 a year for certain families to be housed in welfare hotels in which the conditions are disgraceful. Far better that those persons be provided with vouchers so that they can choose to live where those individuals have the right to live, regardless of their race, wherever they choose to live.
All right, factually, I think that this needs to be dealt with. This is going to a national audience, perhaps, and this issue has got to be dealt with once and for all. In Yonkers, the vacancy rate in apartment houses over the last 10 years has been documented at less than 2%. When a vacancy rate is less than 6%, HUD regulations have said for the last generation that is a trigger for new construction in every single federal housing program. So the idea that vouchers, as I pointed out to you earlier, Ms. Chavez, there are 175 vouchers we got in the consent decree in 1984. About 25 of them are being used at all. 3 of them are being used integratively. Why? There's no supply. And your administration did everything it could to remove the federal government from the business of assisting and providing supply. And that's the truth.
Well, I'm not going to get into an argument here on supply and demand, but the fact is that in a marketplace economy, there will be the supply if there is the demand.
Professor Glazer, one brief word, and then we go.
Since Mr. Sussman came back, I insist on one word. In 1940, less than 1% of the American people lived in public housing. There wasn't any, about 0.5%. There are probably twice as many poor people in the country as there are now. How do you get off saying that if we have poor people, we have to build housing dedicated to the poor? You don't follow? Poor people lived in housing before the government was subsidizing housing that was dedicated eternally to the poor. They lived in poorer housing. They lived in housing that better people had given up. They lived in tenements.
That better people had given up. Listen.
Let me finish my sentence. It is not the case that poor people will not have housing unless the federal government subsidizes housing. It's not the case.
I would like to interject on this point just the example of Boston. And I don't think that anyone here, including Professor Glazer, who is familiar with the housing market in Boston and who is familiar with long traditional theories about filtration and the notion that when well-to-do people relinquish housing, that housing then becomes available to lower-income people. I don't think anybody in Boston can contradict the reality that in the Boston metropolitan area, housing filters only up, not down. Housing in this market does not filter down, and when a unit is given up by a low-income family, it's occupied by a higher-income family, and not the opposite. Yes, over there.
Professor Glazer, do you think that if, say, legally or illegally, the people of Yonkers had been told that well over 75 or 80% of the low-income housing would be given to whites, how different do you think the opposition of the people to that would have been? Do you think, for example, that the quotes that you stated would have been any different? Would the opposition to that move would have been any more intense or less, or would it have been the same?
Depending on which whites, and I think that if the social circumstances I described from the Times articles in the public housing were the same, I suspect the opposition would be close to the same.
You know, one thing that I mean, we talked about public housing, and I know a lot of you probably are aware of this, but all throughout Europe, people live in public housing. In New England, before Margaret Thatcher became Prime Minister, 40% of the housing was public housing, and there was not this issue. Oftentimes what we do in this country, because we have made some progress, you can't use race explicitly, they become surrogate and proxies for race. And so people talk about low-class people, underclass, poor people, oftentimes meaning a proxy for race. There is still more interaction between middle-class whites and poor whites than there is between middle-class whites and middle-class blacks. The class issue is a false issue. People aren't afraid of living next to poor people. The people are afraid of living next to people who look and speak differently than them.
Yes.
Yeah, I just wanted to pick up on a point that Professor Glazer, you made, and I have a statement and a question. Mr. Sussman mentioned the homeless problem in Westchester finally, and late in this discussion, and I was glad to hear it. There are 5,000 people in Westchester, as he mentioned, who are homeless. The average length of stay in a hotel is 13 months in Westchester County. And the problem is getting worse. The federal government, other than the McKinney Act, has done nothing to deal with the problem. We had a 1949 goal in this country of decent and suitable living environment for every citizen. I would say to Mr. Glazer that when we wanted to house people after World War II, when we had returning veterans from World War II, we housed people after World War II. 2/3 of low-income people, contrary to popular belief, live in private housing, unsubsidized. 1 in 4 people who are eligible for housing, for low-income housing in this country, do not get it, even though they are eligible for it. And so I have great problems hearing you say that. I think vouchers are terrific. I think they're wonderful. They're wonderful if you can find a unit. You cannot find a unit in New York using a voucher. So I guess the question I had, you mentioned that you acknowledge that the scattered site low-density housing is better than the old model, but there are better ways to do housing for the poor. And I guess my question would be to you, what are those better ways? If we haven't discovered them yet, I'd be interested in hearing what they are. If vouchers don't work, we're not going to do dedicated construction. We have expiring use restrictions running out in over 700,000 units of housing. What are those better ways?
Well, it's hard at 9:45 to develop a housing program. One of those better ways to get rid of rent control in New York City. I think there'd be a lot more housing if we did. To let up on restrictions on building of all kind, whether to insist on gold-plated units, which are going to be very expensive. We make it very hard to build housing. In New York City in the 1920s, the free market built 700,000 units. And they were perfectly good units until they were destroyed, in the 70s by arson and so on. In the 1960s, we built something like an almost equivalent amount of subsidized housing, and we're very sorry we did. There are other ways, that's all. We've known them in the past. Well, is it that we were idiotic, or we were very cleverer, or something? We have developed policies such that we can't build housing for the poor, and only the government can build it, or at least in many cases. When we come to your housing, the homeless thing in Westchester, I think we have to, because we make it so hard to do anything else, so we have to do things like special units, the kind of thing that, I don't want to mention another Cuomo, but the son of Governor Cuomo is developing in Westchester and elsewhere, small units, substitutes for the motels and so on. But I think this insistence that if the federal government doesn't do it, it can't be done, is silly. We've lived through a whole history in which the federal government hasn't done it, and it's been done. And right now, the federal government is giving nothing to New York City, and New York City is rehabilitating 5,000 units a year of low-income housing, almost as much as was ever done with federal assistance. It'll probably be better housing, too.
Again, I would like to take the liberty of interjecting, not an opinion, but some fact. We talk about what the federal government has done and can do, and I think that that probably should be viewed in the context of what has been done. All of us who own a house, Professor Glazer, Mr. Sussman, Ms. Chavez, Mr. Powell, all enjoy an enormous subsidy in the form of a real estate tax write-off and a write-off for interest on the mortgage that we pay, but very few of us have any sense of what the relationship of that subsidy is to the housing subsidies we provide to low-income families. Been a lot of talk about what the federal government should and should not do. Now, I've lost track of the last 3 years, so you'll forgive me if the data that I'm giving you goes all the way back to 1985. But in 1985, in that single year, the tax write-offs for real estate taxes and mortgage interest were larger than the sum of all of the rental subsidies to low-income housing since 1937, when the Wagner-Steagall Act was passed and the first public housing project was authorized. So we need to keep some kind of perspective on what the federal government does and what it can do. Now, yes.
Elleria, I'm a student here at the Kennedy School. I wanted to refer to something that Ms. Chavez said about her concern that we would have an extension beyond the direct forbidding of discrimination by law. It seems to me that that comment seems to imply that by forbidding discrimination, that we've done away with it somehow. And I just note the strong feeling that's generated here in the audience tonight, and it's not over Yonkers, it's over discrimination in this country against black people. And I would like to just note one example and ask what kind of solution you see when the law forbids discrimination. And I have this experience of living in New York City in a working class neighborhood, a middle class neighborhood, and the apartments are never, or most of them are not publicly advertised. So the area has less than 1% black population. It is forbidden by law to discriminate against blacks in my neighborhood, but that's what exists at the present time. That's the real problem. What do you see as a solution?
Well, first of all, the most egregious examples of the failure to advertise and the passing on of apartments from one to another is, as Nat Glazer referred, to rent-controlled apartments, and that's true in New York City, and it's true in other areas of the country that have rent control. I think the best analogy that was devised to answer your question was one that was used by Lyndon Johnson when he launched the War on Poverty. And he said that it was not simply enough, in referring back to the first questioner who talked about the legacy of slavery in this country, that it was not enough simply to remove the chains from people in a race who had been chained, and to expect that they would be able to run the race at the same speed as those who had not been so encumbered. I think the problem was that in that analogy, our solution with affirmative action has been to set people halfway down the track, or to insist that a certain number of people who had faced discrimination in the past be guaranteed to the winners in the race. And I think the more proper focus of our attention would be to provide the training and the skills to those persons who have been encumbered by the effects of past discrimination, so that they could achieve on their own merit. I think that's what equal opportunity is all about. I think efforts that are aimed at providing that equal opportunity are things that I certainly endorse and that I think the vast majority of Americans today would endorse.
Let me just add one thing.
I'm being signaled that our time is up, and I'm terribly sorry. I know both our panelists and all of you in the audience would like to carry this on for a much longer time, and I wish we had the opportunity to do that. Certainly it's clear that we haven't, and we're not about to bring this discussion to closure here tonight, but I think we've been able, through this exchange of views, to really expose what the issues are, what the differences are that divide us very deeply, and which lie at the heart of many of the deepest problems that our society has yet to resolve. Thank you all for coming. I wish we had more time to deal with your questions. Good evening.